During the last 6 months, we've all heard mention of possible charges that could be brought in this case. It's important to understand that all of the charges that have been mentioned have specific meanings and ramifications. Criminal homicide encompasses the taking of a life by another. While there are 6 possible homicide charges under Kentucky law, these charges are not applicable to the facts before us because our investigation showed and the grand jury agreed that Mattingly and Cosgrove were justified in the return of deadly fire after having been fired upon by Kenneth Walker. Let me state that again. According to Kentucky law, the use of force by Mattingly and Cosgrove was justified to protect themselves. This justification bars us from pursuing criminal charges in Miss Breonna Taylor's death. The success of our legal system is predicated on the principle that the accused is innocent until proven guilty. Despite passions, opinions, and desire for every detail to be known, the rule of law must apply. Justice must be done. In the early morning hours of March 13th, officers from LMPD executed a search warrant at 3003 Springfield Drive, apartment 4. This was Miss Breonna Taylor's residence. The officers were advised by superiors to knock and announce their presence in serving this specific search warrant. Sergeant Mattingly and Detectives Cosgrove and Hankinson had no known involvement in the preceding investigation or obtainment of the search warrant. They were called into duty as extra personnel to effectuate the service of the search warrant. They only had information conveyed to them during their prior briefing. Evidence shows that officers both knocked and announced their presence at the apartment. The officers' statements about their announcement are corroborated by an independent witness who was near in proximity to apartment 4. In other words, the warrant was not served as a no-knock warrant. When officers were unable to get anyone to answer or open the door to apartment 4, the decision was made to breach the door. After breaching the door, Sergeant Mattingly was the first and only officer to enter the residence. Sergeant Mattingly identified 2 individuals standing beside one another at the end of the hall, a male and a female. In his statement, he says that the male was holding a gun, arms extended in a shooting stance. Sergeant Mattingly saw the man's gun fire, heard a boom, and immediately knew he was shot as a result of feeling heat in his upper thigh. Kenneth Walker fired the shot that hit Sergeant Mattingly, and there is no evidence to support that Sergeant Mattingly was hit by friendly fire from other officers. Mr. Walker admitted that he fired 1 shot and was the first to shoot. In addition to all the testimony, the ballistics report shows that the round that struck Sergeant Mattingly was fired from a 9mm handgun. The LMPD officers fired 40 caliber handguns. Sergeant Mattingly returned fire down the hallway. Mattingly fired 6 shots. Almost simultaneously, Detective Cosgrove, also in the doorway, shot 16 times. This all took place in a matter of seconds. In total, 6 bullets struck Ms. Taylor. Medical evidence obtained by our team indicates that only 1 shot was fatal. Further medical evidence shows that Ms. Taylor would have died from the fatal shot within a few seconds to 2 minutes after being struck. Detective Hankinson fired his weapon 10 times, including from an outside sliding glass door and through a bedroom window. Some bullets traveled through apartment 4 and into apartment 3 before some exited that apartment. At the time, 3 residents of apartment 3 were at home, including a male, a pregnant female, and a child. There is no conclusive evidence that any bullets fired from Detective Hankinson's weapon struck Ms. Taylor. The KSP ballistics analysis did not identify which of the three officers fired the fatal shot. After receiving that information, I asked the FBI crime lab to conduct its own analysis to see if they reached the same results. The FBI ballistics analysis concluded the fatal shot was fired by Detective Cosgrove. I think it is worth repeating again that our investigation found that Mattingly and Cosgrove were justified in their use of force after having been fired upon by Kenneth Walker. Yes, sir.
One big question surrounding this case is whether or not the officers knocked and announced their presence. Talk about the evidence that you came to that they did announce their presence.
Yes, the statements that were made by officers there the night or the morning of March 13th show that they did knock and announce. The important point here is that information was corroborated by another witness who was in close proximity to apartment 4, who corroborated that information and said that there was a knocking and announcing by the officers.
Was the witness a civilian or a law enforcement?
The witness was a civilian. After hearing the evidence from our team of prosecutors, the grand jury voted to return an indictment against Detective Hankinson for 3 counts of wanton endangerment for wantonly placing the 3 individuals in apartment 3 in danger of serious physical injury or death. The charge of wanton endangerment in the first degree is a Class D felony, and if found guilty, the accused can serve up to 5 years for each count. Kentucky law states that a person is guilty of wanton endangerment in the first degree when under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. My office is prepared to prove these charges at trial. However, it's important to note that he is presumed innocent until proven guilty. The facts have been examined, and a grand jury comprised of our peers and fellow citizens has made a decision. Justice is not often easy. It does not fit the mold of public opinion, and it does not conform to shifting standards. It answers only to the facts and to the law. With this in mind, we must now ask ourselves, where do we go from here? Will we continue to prosecute the charges brought in this case as it now proceeds through the justice system and moves to trial? That is our responsibility. And this will be done while the FBI continues its investigation into potential violations of federal law. I know that not everyone will be satisfied with the charges we've reported today. My team set out to investigate the circumstances surrounding Ms. Taylor's death. We did it with a singular goal in mind, pursuing the truth. Kentuckians deserve no less. The city of Louisville deserves no less. Every person has an idea of what they think justice is. My role as special prosecutor in this case is to set aside everything in pursuit of the truth. My job is to present the facts to the grand jury, and the grand jury then applies those facts to the law. If we simply act on emotion or outrage, there is no justice. Mob justice is not justice. Justice sought by violence is not justice. It just becomes revenge. And in our system, criminal justice isn't the quest for revenge. It's the quest for truth, evidence, and facts, and the use of that truth as we fairly apply our laws. Our reaction to the truth today says what kind of society we want to be. Do we really want the truth, or do we want a truth that fits our narrative? Do we want the facts, or are we content to blindly accept our own version of events? We as a community must make this decision. I understand that Miss Breonna Taylor's death has become a part of a national story and conversation. But we must also remember The facts and the collection of evidence in this case are different than cases elsewhere in the country. Each is unique and cannot be compared. There will be celebrities, influencers, and activists who, having never lived in Kentucky, will try to tell us how to feel, suggesting they understand the facts of this case and that they know our community and the Commonwealth better than we do. But they don't. Let's not give in to their attempts to influence our thinking or capture our emotions.